Okay, hey, we're live here. I'll give people a little bit of time to assemble and get going on here. I am Anthony Parent of IRSMedic and with John Richardson, and I'll introduce my guests in a little bit of time. I just wanted to explain, I have a little bit of an introduction for today's topic. We have this instance where the government is seeking FBAR penalties from a New Zealand couple. And the penalties are well over $1 million. And what I'm seeing in this case, as I read through it, are things that I've seen firsthand, and unfortunately, just how utterly abusive and insane. And really, I think that's really the word we should use to describe this government is totally insane, and why, as we get into this a little bit. And this is really the point I want to start off with: is that have you ever done a favor for someone and you've been punished for that more than anything else? That you trusted someone to be fair, you trusted someone to see the truth and be reasonable, and then get brutally punished for that, unbelievably punished and humiliated. Well, that's what this case is about. That's really what this case is about. We have James Barrireau and his wife, Catherine, and they live in New Zealand. They're U.S. persons, and because of that, they are subject to the whole entire regime, as the government claims, of filing FBARs and all this nonsense that the government claims that you have to do. Now, they were just like many of my clients who I represented. They went through the offshore voluntary disclosure program. And the government doesn't quite say that in its complaint, by the way. Never really says that. It just says, it just sort of mentions there, oh, okay, and because this is how you know that they went through the offshore voluntary disclosure program, because these are the years of 2006 to 2013. So sometime they filed an offshore disclosure in 2014. So that was an expensive thing they did. I know that, because we charge way too much money for what we had to do. And that is really about, we're going through this like, okay, well, that's weird, because if you have just a basic understanding of the statute of limitations, and this is the point I want to make, that number one, they came clean. They came clean. Say, oh, I have a problem. You know what? I don't want you to track me down, IRS. I have a problem. I'm going to come clean. I'm going to file what I need to do. The IRS didn't find them. But now the IRS is punishing them as if they found them. And here's the other thing, too, because your FBAR has a 5-year statute of limitation on penalty assessments. Well, here it is. We go up here, and the government assessed the penalty in 2023. We'll see that somewhere. But geez, the last penalty was 2013. So what gives? What gives? And now here's the untold story in all of this. The Barrireaus must have filed multiple consents to extend the statute of limitations. That is, the government says, hey, we're still working on your case. By the way, they dropped these cases and weren't working on for years. Like, hey, we're working on your case. In order for us to be fair to you, we need you to sign this statute of limitations to extend the statute of time for us to assess the penalty. And so that's what they did. And that is where, the trust, the government just breaches the trust, because they went ahead and trusted the government and were painfully punished for it. And I can tell you right now, this is really the thing. And honestly, this is sort of the sad thing about this. As I look at this case, I'm not sure what time of the year they did this. But if this was a disclosure they made in 2014, what could be the most horrific thing is if it was done after June 30th, because the Streamline program was open. And what I could tell you is everyone qualifies for the Streamline, and everyone does. And the developer of the OVDP plan even said that himself. I talked to him. He says, oh, yeah, everyone qualifies for Streamline, meaning that they would have no penalty whatsoever if they either got different advice or just waited a little bit of time, which I don't know. So that is what I just want to start this off with, just the background, so that people understand that how this case and this penalty got here is, number one, the Barrireaus came clean. They might have been too early, or maybe they got the wrong advice, but they could have easily avoided any penalty in a much easier OVDP if they were just a little bit later or got different advice. I don't know, and I'm not necessarily, and I don't know the facts there. And now here they are, lined up, teed up, because we have the DC court the enemy of expats, because the DC District Court is what it administers expats. The worst court in the country by far when it comes to tax. They are absolutely the worst case. And if you are a U.S. expat, what I would say, you're your worst enemy. So now with that, now Keith, I was talking to you a little bit about this beforehand. And with me today is Keith Redmond. He is the global navigator for Americans abroad, so he knows this stuff inside and out. Keith, and you're talking to people all the time, all day long now. You've been very, very busy, you told me, right? So what's going on?
No, I don't know why. I mean, it's just a big influx of people trying to figure out how to navigate, their particular situation. It's basically what it is. So I'm just kind of, I maybe confused is too strong a term, but I'm just wondering what is so special about, and John's going to be able to answer this particular case where they got caught up in the FBAR penalties, because when you look at it, it's in entirety, and the data, which I think the last data that came out in 2022, the majority of Americans overseas and even Americans in the US just don't file FBARs. So I don't understand what was so
Yeah,
special about this. You know what I
yeah,
mean?
and I mean that's really what John and I have said. The greatest risk, the greatest risk to be assessed a penalty is to file the form. If you want to increase your chances of a 3520 penalty, is to file a form, because
You
then
mean
like, oh
file?
well,
You mean file the form? You mean file the FBAR?
yeah, and that's what it is. So in this case, what their mistake was is they trusted the government. Again, they went to the offshore disclosure program. This is a case, and this is why
Well, that's what. Yeah, yeah. I'm sorry, Nancy. I don't mean to interrupt. I really don't. But okay, they followed the offshore disclosure program. Great. Okay. So then what happened? That went.
oh, okay. So
What was
great,
their big
thank you, Keith.
cock up?
Yeah,
You know what I mean?
yeah. All right. So this is this is the reason why. Okay. So these are people who likely, just like most expats, didn't do anything intentional, and regardless if it's intentional or not, penalties need to be, through some sort of judicial process, regardless of whether penalties are appropriate or not. They need to be followed a judicial process. So what the OVDP is, if you recall, was kind of a one size. It was a take it or leave it proposition.
Right.
So the government said, hey, look, you got to go through this thing. And now our standard terms are we need 8 years of returns, even though there's a statute of limitation of 6 years. They made a special exception for that. We need 8 years of returns in all your FBARs, along with a 27, because this was going to be under these program rules, a 27.5% penalty on the highest account balance of any of those years. Now,
Okay.
you could imagine somebody could have a high balance because of maybe something came in there. Maybe there was some money,
Selling a home,
right,
and it was
selling a
there for a
home,
couple days. Yeah.
right. And so you have 8 years to capture a really high balance, right? So, hey, look, the money kind of come in there, out there in a second, but now the government's saying, yeah, well, we want 27.5% of that money that was temporarily in there. So what was happening is and their attorney said, hey, look, the IRS does have an opt-out process that if you do believe you're non-willful, you can elect. And this is what we did. We did this in many, many cases, and probably more than any other firm I know of. We opted out, and we had tremendous success in opting out. Only one case didn't work out. Only one case didn't, which actually, no, there's two. One of them, there's two where they assessed non-willful, but it was so inappropriate. And that case went to litigation. Unfortunately, it didn't go great. And then the other case is currently in litigation right now, and I do think that there's going to be a relief eventually. So the point is that if you wanted to avoid that penalty, you had to opt out. But then when you're doing that, you're throwing yourself at the mercy of the IRS, because now you have to convince the National FBAR Penalty Coordinator that you were non-willful. And this is what I could tell you, that there is no rhyme or reason to who is willful or non-willful, but rather the one thing that I have found that determines willfulness versus non-willfulness the most in my vast experience of these opt-outs and these penalties is if the person is elderly. That is the number one determiner of how harsh the IRS is going to be. So what my guess is that the Barrireaus are probably retired. They're probably,
Okay.
a little bit older, because that's who the IRS wants to attack. So they went after someone, and you just got to imagine these are just normal expats, right? And now you have the weight of the IRS coming down on you. Like, this is so insane. It's utterly insane. And this is after you wanted to come clean. And this is what we this is where it's just my contempt for the IRS, because they said so many things about, hey, if your clients do this, it's going to be good. It's good. If you listen to the words of the IRS, you could have put your client in a really bad spot. And so they're very disingenuous, and they really did a bait and switch. And so that's what's really disgusting about their behavior in this case. And I think really on top of it right now, what's utterly disgusting is right now there is a district court case that applied SEC versus Jarkesy to FBAR penalties. Say, hey, we can't do this, folks. There's no jury trial here. And if we go down to the complaint, John might have a little bit in his slides, and we'll get to that in a little bit. But this just stuck out to me here is when we get to something like this. On the complaint, here we go. Barrireau's failure to timely report his interest in his foreign bank accounts for the years at issue was willful. That's all they have. And I'm like, well, that's not even, well, that's a conclusion. I'm going to strike that. I would say, I don't think that's actually, where did we get that? How's the allegation? And the thing is, the Irish just made it up on their own. The Irish just says, hey, we're going to make up a judgment on our own. So do you see that's what's going on?
Yeah. I guess the other thing, and it might be outside the remit of this particular podcast, I'll just put it out there because maybe John will answer it or be able to answer it, is what I asked you before we started. I said, with all these penalties and all that, if you have no financial ties to the U.S. and you're not planning on going to the U.S., how could they collect the penalties? That I don't understand. So, and like I said, it might be out of the remit of our podcast, but I'm just
and I would say this. I know we have a lot of people. We have some genius followers on here. Now, there is a case, guys. If you guys could pull up, if anyone could find the case that I'm looking for, I looked for it right before because Keith asked me. I swear I was reading a case about where somebody was being held in contempt because, John, maybe you know it. He's being held in contempt because he wouldn't surrender money from overseas to the U.S. government, and I think it was for an FBAR penalty. What is it?
Schwarzbaum, I think.
Oh, it's Schwarzbaum. Okay, it is. Oh, all right. So it's Schwarzbaum. Okay, I think that's what it is. All right, I'll pull that one up. All right, great. So I think that if we look at that case, I'll pull that up. But I think before that, I think now we got the ground set for John. We got the ground set for the great John Richardson. Thank you for your patience, everyone. Here we go, John. You know what I'm going to ask you. Are we ready to go? Do you have it? Do you have your 30? There it is, 32 ounce McDonald Land coffee. The great John ladies and gentlemen, the great John Richardson. Let me get this slide start at the beginning. Here he goes. I went through these slides. Great presentation. So here we go. Mr. FBAR turns 55. Hey, that's right. 55, Mr. FBAR. Here we go. Life in progress. So here's his memoirs. The memoirs of Mr. FBAR. So good morning, John. We're ready for this. Yes. All right, here we go.
I think what's important to understand here is, why are we doing this today? Look, what has happened to the Barrireaus, by any standard of humanity, is depravity in the extreme. Okay, what they did here, the total FBAR penalties assessed against these people, I think this is just from the government, right? This is what they say. This is not what I say, what you say. This is what the government is saying, right? Is about $3.5 million, which, is clearly a very, very significant part of their net worth. Who knows? It may even be their net worth. I really don't know. But from that point of view, it's outrageous. Begin with, as far as the context goes, Anthony, I think you're absolutely right. I think this must have been somebody who entered the 2012 version of OVDP, not the 2014, the 2012. Yep. And to put this in context, right, what this really was basically a program created for people who had non-U.S. assets and income streams that had not been reported to the IRS. And the idea was that they would pay basically in lieu of all 5471, 3520, FBAR, all these penalties, they'd pay flat penalty of what went up over the years, but by 2012 was 27.5% of, I think, the highest balance. So, that was steep. Okay, a lot of people view it as a good deal to avoid prosecution, and that's how it was sold, by the way. Okay, that was how it was sold, a way to avoid criminal prosecution. But the interesting thing was that a lot of Americans abroad got sucked into this. We can look back and say, they had really bad advisors. That may be true, but you have to, I think, evaluate this stuff in the context of the times, which is really pretty bad and pretty scary. But for Americans abroad to enter the OVDP program, let's say you're going to pay a 27.5% penalty. For Americans abroad, that would have been, 25 point, whatever that was, 5% of their total net worth, right? In most cases.
Yeah, that's really what it is, right? Yeah. And I would say this, and again, John, the other problem is that, look, you're having 8 years to look back, so the chances of you having that same amount of money go down. And hey, look, you capped a snapshot. That's the problem. That it's actually not necessarily your current net worth, but some fictional thing that you're getting penalized on.
That's exactly right. And that's sort of, technically how it'd be calculated. But what needs to be understood here is that to even pay that kind of penalty, these Americans abroad would have had to have liquidated assets, which would have been eroded because of tax payments. So for many of them, the deal really was, if properly understood, and this shocks the conscience. It shocks the conscience, right? What it really was, you know what, if you give the IRS 50% of your net worth, we won't prosecute you for not knowing about laws, okay, that were never, very well publicized, right? So, just think about that for a minute, right?
Well, and so not only that, well, it's not even a law. We, as we go on, we'll go through that, and I went through your slides, so we can explain that a little bit.
That aside, let's just imagine, okay, I'm talking, really about the tax thing, and it would include FBAR and stuff like that. But what people were faced with was some tax advisor telling them, well, we've got great news here. The bad news is that you're nothing but a common criminal.
Right.
Okay, the good news is that we have a remedy. If you pay them 27.5% of your net worth, which, by the way, means it'll cost you half your net worth by the time you get the money to pay for it.
Yep.
We'll make sure that, that you're not going to be prosecuted criminally. So, this was frightening. And of course, it was shocking. And the people who did not go into the program and had tax advisors or legal advisors who told them to not go into the program, I think, clearly should be congratulated because, of course, the streamline, came out after that. And as you point out, Barrireau should not have been in any kind of OVDP program to begin with, whatever. But this is what was actually going on. It absolutely shocked the conscience. Now, a lot of people, see, you never do anything. You never, ever, ever do anything in this area without having tax returns prepared, just to see what's going on. These forms prepared, because that's how you communicate with the government. And what happened clearly was that, the Barrireaus decided that, it looks to me, so first of all, they owed no income tax. The government's claim and this is that the money in the accounts came from his high salary as an English teacher. Is this for real? Okay, this guy's an English teacher in New Zealand. He's paying tax in New Zealand. Are you seriously suggesting this guy owes U.S. tax?
Or here it is. Going to New Zealand soon. Gonna be an education tycoon, right? I
know, incredible, right? Or his wife. Okay, the money apparently from parents, right, from relatives. It's very, very clear that this was not an issue of anybody owing U.S. tax. It was solely a reporting issue. So what happens is that, they get the bill, okay, what the standard OVD penalty is. And I think that it was somewhere around $1 million. I don't know, but it was far less than the FBAR penalties assessed. So then what happens is they use the opt-out thing, and when we get to the slides in a minute, I'll show you what the opt-out says. Okay, it says, well, we're gonna, go after you according, to the law without OVDP, et cetera. And that's what we need to talk about, what the actual law of FBAR is. But the end result of it is that they assess them with penalties that appear to be far in excess of what the standard penalties would have been in the program itself. I don't know these people. I don't have access to the numbers.
Yeah, I don't know them. Right, they're not clients of mine. And I would just add that I don't see any evidence that their attorneys did anything wrong. Just so you know, that this is not.
Oh no, that's not the issue. That's not the issue at all. That's not the issue. Now, so I think what we need to do, right? So let's say you opt out, and the government says, all right, fine, so we're just gonna, process your thing in the normal course, right? Assess whatever penalty. So the purpose of the discussion today is what really is the law of FBAR, and what are the penalties that should be assessed? And I want to begin this by asking you and Keith a question. So my question here is this: what's the penalty for not filing an FBAR? What's your understanding of that?
Well, from a layman's point of view, my understanding is based on the percentage of your highest balance that you have on any given year that's going to be assessed. So it's not a set penalty.
Okay, Anthony, how do you see it? Somebody who says, I'm sure you walk down the streets and people recognize, oh my God, you're the great IRSMedic. I just have a question, a small question. Could you tell me what the FBAR penalty is? And what would you say, Anthony?
Oh boy. Yeah, I guess depending on the context, if somebody want to know, what level do you want to know it? And so I would say, I'm right. I'm like, my answer's not going to be like, okay, you got me stumped. I have too much to say.
All right, Anthony, you're having a high level thought. You need to ask somebody who thinks real simple. Why don't you ask me? I don't know anybody more simple.
All right, here we go. All right, hey, John, if you're walking down the streets of Toronto with your 32-ounce McDonald's coffee, and someone stops you, as someone who's also micro famous like I am sure people stop you on the street and ask you, John, what's an FBAR penalty?
Okay, well, that wasn't quite the question, but we'll answer that one as well. Well, an FBAR penalty is, we'll start with that. Oh, it means, you live in Toronto, right? Yeah. You lived in Toronto your whole life? Yeah. You have a bank account in Toronto? Yeah. Where is it down the street? Well, what an FBAR penalty is, if you don't report that bank account you have, your lifetime bank account in Canada down the street, the financial crimes of U.S. Treasury, they might want to penalize you. So that's what an FBAR penalty is. But the question is, what's the amount of the penalty? Okay, and the correct answer is 0.
0?
Ask me
really?
Again, so you hear the answer. Go ahead, ask me again.
John,
what is the FBAR
penalty? The penalty?
No penalty required. Should be 0. There's the introduction of the presentation, because I just want to make a point here that I think that the tax preparation legal industry is complicit in churning FBAR penalties for reasons that I'll explain. So here we go, Mr. FBAR.
All right, that's gonna be great. And Andy, for some reason, Andy's trying to send me over definition of citizen. Andy, it's not coming through on X.
Okay, truth, justice, in the American way. Here we go. Okay.
All right, here we go. This is it. This is good. All right.
So here we go. So what we know is this. Okay, now this is just an oversimplification. Then we'll dive in. Basically, what it is this. Okay, every U.S. citizen or resident is required to look at all their non-U.S. accounts, identify the highest balance in the year, converted to U.S. dollars at the December 31st U.S. Treasury exchange rate, and should the aggregate be over 10,000 U.S. dollars based on that exchange rate, they have to file forms with financial crimes. That's what it is.
This is the political process. Yes, this is what people wanted. Yeah,
exactly. Of course they want it. It's truth, justice, in the American way. And there are complicated rules when you have an interest in a trust or a corporation.
There we go. Right.
All right, so that's what it is. Now let's break this down because this is fascinating. Okay, fascinating. Even people who are not interested in this stuff will find that fascinating. I feel as though I'm anyway. Okay, go ahead. Next. All right. Now that's okay. Next slide. So that's
All right.
the simplification, right? Now let's go back and talk about Mr. FBAR a little bit, because when he arrives in 1970, proudly introduced by the U.S. government as our newest, most important citizen, his purpose was to identify money laundering committed by homeland Americans. But as he grew up and his purpose and stature has evolved, what is his purpose as an adult in 2025? Well, I think the obvious definition is the form, no pun intended, of terrorism committed by the U.S. government against Americans abroad, of which the Barrireaus are an interesting example. And
well, I would say also all Americans. It's financial terrorism, which is terrorism. Terrorism is what it is. Correct.
Okay.
Right.
There we go. Next. Now, I also want to make the point here, and I think this is critical. Make no mistake about it. No mistake about it. This is written right there in the statute. The Treasury has the power to exempt Americans abroad from the FBAR requirement. There's the text. But will they do it? No. But they have the power to do this. And there's a link to a submission I wrote in 2024 on this topic. Next. Now, before we get into this next section, I was thinking about this. It's funny, I put these presentations together and I kind of rethink a lot of this stuff. But we have this unbelievable mixture, right, of statute, Treasury regulation, going back to the statute for penalties. But the bottom line, the bottom line is this, that we know, and let's not get into, much on this, but the statutory authorization, as it's understood for FBAR, comes from 5314. Okay, we know that. But all it does, here's all 5314 the statute says. Okay, if we really get down, it says, you know what? We in a general sense, we want reporting here, but we're going to delegate it. We're just going to send it right over to U.S. Treasury to make up the exact rules, all right, for what has to be reported, when, where, how. And by the way, you'll notice there's no reference to any $10,000 in there at all. That all comes from Treasury, right? Treasury could, raise the threshold. The threshold. Do they do that? No. Why? Because the purpose is the penalty and the penalty is the purpose. Okay?
Yeah.
Now, I also want you to understand, all right, that Congress has authorized Treasury to create these rules, interpret the rules, police compliance, and impose, now this is key, listen carefully, any penalty up to the statutory maximums, right? In other words, the law allows them to impose a penalty. They don't have to impose a penalty, but if they impose a penalty, it cannot exceed the maximums in the statute, right? So this whole business of, 50% of the account, this is not in the statute. These are in the statute to the extent that they're statutory maximums. That doesn't mean that those are the amounts of the penalties that are supposed to be imposed. But anyway, continuing on. Next. Okay. Now, we've talked about this, but I think it's really clear. Okay. What's really clear is that the law requires the secretary to require a resident or a citizen. Now look at this next part that nobody even seems to know is there, or a person in and doing business in the United States. I mean, my God, somebody flies to the United States for a business meeting. Have you filed your FBAR? I mean,
wait a minute. What?
Yeah.
So, I'm sorry. That one was a little. So, if you're flying to the U.S. and you're a Frenchman, then you're supposed to file an FBAR on your French bank account. Is that what you're saying, John?
This is what the statute says. This is what the statute says. I mean, I don't know why they don't have FBAR filing machines at every airport before you can leave the United States. This is the American way.
Well, and this is what I would say is that the reason why it actually that part of the statute makes sense once you read the statute correctly, because what the FBAR, and again, we're not going to get too much into this, but what the FBAR is, it's a report of foreign agency transactions. You're supposed to report all your transactions with foreign agents. So it has nothing to do with reporting a bank account. It has nothing to do with it, and that's really the problem. They invented it. They invented it, so that actually makes sense that it would be, and that's why they don't interpret it, because they've created a different law. They've created a different law out of it, and we'll move on though. I don't want, because we can get to that very quickly. I don't want to harp on it too much.
Yeah, we've talked about that before. Now, on the issue of citizen, now here's a bit of a nugget, okay, that I've not seen discussed. But this is really interesting, because remember that FBAR does not come from the Internal Revenue, it comes from the Bank Secrecy Act. They use the word citizen. The question is, do they mean by citizen under the immigration rules or under the Internal Revenue Code? Now, why does this matter? Because you could have an individual who relinquished U.S. citizenship under the immigration laws and is no longer a citizen, does not have a CLN, but would still be treated as a citizen under the tax laws. You see what I'm saying? Right? This is an interesting question. You know, I haven't seen anybody get into this, but this is an interesting question. Next.
I just want to hear, and I just want to briefly. I asked Andrew just to get me this here. Hang on, this. Okay, so this is just the the definition, the legal definition according to the maxims, which cannot be altered by statute, but they always are. This is just sort of what a citizen is. Now, one thing I was discussing over the last couple of weeks is that it says we the people. It doesn't say we the citizens. And so there's all these statutory created statuses that sort of take these common law concepts and they misconstrue them to mean things that they really don't. And so that's one of the things going on. That's just one of the many things going on with the perversion of law, because we have words that don't mean what they mean. And that's just a big problem. Don't expect to have clarity. Don't expect to have a rule of law if words can mean what they don't mean. And so just a point here that there's also a entirely different definition of citizen that someone could come up with, regardless of what John has in his statute. So I just wanted to get that out there. All right, that was it. Thank you for indulging me there.
Okay.
All right, so what do we mean by citizen? Yeah.
So continuing on here. Okay. Now, to Keith, answer your question. Does this really mean any non-citizen doing business file an FBAR? No. Why? Because the Treasury regulations, under their authority to exempt people, has exempted people who are neither citizens nor residents. That's the reason. And there's one of my best posts ever on FBAR. This is a 2016 post where I discuss this problem. Okay, but the point here is this, right, Keith, and especially Keith, but everybody, right? Treasury has exercised its statutory authority to exempt a group of people, right? Specifically, people who are neither citizens nor residents. They have proven that they have exercised this authority. They can and should exercise it for Americans abroad as well. But anyway, next.
This is all sound. This just does sound a lot like a criminal conspiracy. I got to be honest.
Well, we'll get there. Now, when you get to the penalty provisions, what's fascinating is that, you go to a seminar put on by some law firm or accounting firm about FBAR, they're going to start with the penalty. Here are the penalties. Here are the penalties. That is total bullshit, okay? If you read the statute, all right, they are not required to assert any penalty at all. The statute simply prescribes the upper limit for what the penalties can be. Now, pause for a minute. When we go to the Barrireau, they didn't even have to assert a penalty, but they did. And the reason is this, that when it comes to FBAR penalties, in terms of the statute, right? No making anything up. In terms of what the statute itself says, the plain reading of the statute, it is clear that any FBAR penalty asserted by the IRS is because they want to assert it and not because they're required to assert it, right? So put this in the context of the Barrireau. The IRS decided that they wanted to, even though they didn't have to, that they wanted to hit these people up with $3.5 million in FBAR. Make no mistake about it. This was not the result of law. This was a result of IRS discretion. Next. Now, here you'll have, now there are two kinds of penalties, of course, civil and criminal. Now, it's interesting because, so we start with the statute that punched it over to Treasury to make up rules, and then violation of the rules, we come back to penalties by statute, right? Now, I'll tell you what's interesting here, though, is that what we have is the government being judge, jury, and executioner, right? I mean, who decides whether to impose a willful or non-willful, among other things? But here we go. On the civil thing, non-willful, and the Bittner case from whatever it was, a year or two ago, says for non-willful, they're limited to one penalty per form of $10,000 a year. For willful, it's greater, 50% of the account balance, or 100,000, et cetera. Now, I want you to notice something about that. We go to criminal penalties next, 5322. Notice that the civil FBAR penalty, the authorization is higher than the criminal penalty. Move to 5322. They can be punished.
Hang on, sorry. Multitasking. Hang on 1 second. Just yeah.
Isn't that interesting?
Now, I would say, and by the way, and just let me go back. One thing I just want to point out in right here, you said, but remember, how this is civil, it comes from financial crimes, right? So what we have here, just, hey, look, all we have is IRS civil employees assessing basically criminal penalties, because non-willfulness or willfulness is a determination of specific intent. Because these are civil employees who are trained to be examiners, so we obviously should have them. They're in the best position to be that judge, jury, and executioner, right? Because their understanding of the law is basically nothing, and they are biased to get it done as whatever their boss tells them to do, and torturing and threatening people and making them feel terrible is the perk of the job. That's what they like to do, is they like to punish people. So I just want to get that out there. It's like, while it's civil, it is criminal. It's assessed criminal, and the way, by criminals. And that's really what we have here. This is a criminal government doing this. I think that's the point we need to make clear. This is absolutely insane. A violation of the statute, of the regulations, of common law, the Constitution. It's a violation of everything. This is just terrorism to get people. That's all it is. It's just like, we want to just have a world where we can terrorize people and we can rule over them and we can send them through any humiliation ritual that we want to, because we like to, because we're told to do that, because, well, money laundering, right? There we go. So I just want to get that in there.
Yeah, I think that's right. Look, I don't know that I'd use quite the degree of emotive language that you just used, but I think it's very, very clear that this is a situation where essentially Congress has given Treasury to, create a situation to force people to do anything they want, and then decide what the penalty is if they don't. I mean, this is extraordinary stuff. It reminds me almost of extraordinary rendition. Okay, during the war on terrorism, etc. But anyway, next. Okay. Now, where do the rules come from? It's very important to understand they come from a regulation. And, you can go to these links, right? And it's lengthy, and I don't know, but that's there. I mean, you notice the statute itself, the governing statute, doesn't set the threshold for reporting. It doesn't, really say much about how this is to be accomplished. And it's the regulation that does. It's the regulation that sets the rules. In other words, the statute initially compels Treasury to make up a bunch of rules, okay, for requiring reporting of foreign financial accounts. There's a statute, okay, that limits the amount of penalties that can be imposed, but it's up to Treasury, okay, to assess penalties, assess willfulness, et cetera, et cetera. Next.
Well, I just want to say something that, this regulation is the law, because the law is very different than this regulation. Quickly, that's a Loper Bright violation, which brings up the point. Why would they want to bring this case when there's a real dispute over whether or not this would actually be any way illegal? Now, and this is the thing, and just one thing, it's like I've seen this in the Doug Edelman indictment, in that the criminal violation of the regulation, because they too know they don't have it. So you'll always see that. They'll always see, oh, it's a violation, a criminal violation of a regulation. There we go, folks. There it is. That's what we have. This is the actual law on the FBAR, because the statute says something totally different. So that's, I think, the important thing here, and that's why you'll always see them.
That's important. And I think, by the way, that I think it would be hard to get a criminal conviction on this under the Cheek standard, because not only is specific intent required, but you have to know that you're violating the law as well, right? And this is so,
Right.
I think that might be hard. But anyway, next.
Well, then again, you don't have the violation of law; you have the violation of the statute. So that's your problem criminally. There's no. What are the elements of the crime? Like, hey, look, crim law. If we go back to crim law, you go through the elements of the crime. Sorry, that statute. That's it. So,
all right. So again, now implementing the rules, right? So we've got the regulation, we've got the law. Now the implementation is a combination of FinCEN and the IRS. And I think that FinCEN should be viewed. I saw a movie about Orwell on the weekend. Isn't it the Ministry of Love? That would be FinCEN, right? And
I think that's the Ministry of Love. Yeah.
Yeah, and there's where you find out about that, but they delegated that to the IRS. So next.
And again, they delegated it to the IRS because FinCEN said this stuff has no intelligence value whatsoever. We don't want to bother with it because it's just people who are filing who aren't committing crimes. So IRS, here's all this. Go and assess penalties because hey, we don't care. Yeah, that's what that is.
Now, the IRS, has done some pretty bad things here, including the Barrireau thing. But generally speaking, this is where you get things like the delinquent FBAR submission procedures. And I think it's anybody's interested in this really ought to read the Internal Revenue Manual on FBAR penalties, the guidelines, where they make the point that the purpose of penalizing is to promote compliance, and that in many ways a warning letter is the best result here, not the penalty. Again, it is a great mistake, and I really think that the lawyers and accountants, need to redefine the way they describe this. Basically, it's a penalty. No penalty is required. It's only if the IRS decides they want to penalize you. I think it's very dangerous to start talking about default penalties of $10,000 or this, that, because that is just not what the statute says. It is not what the law is, et cetera, et cetera. And I think that as lawyers, and I think I would include accountants, right, maybe to a lesser extent, but I think that lawyers have an obligation to describe what the law is, and not an exaggeration or a caricature of it. There is no required FBAR penalty, and there should be a presumption of no penalty. Next.
That's right. One thing I did, I can't remember what it is. We'll just move on. Hopefully I remember my point. All right, go ahead, John.
In interpreting this stuff, it's very interesting because the last few years have been very interesting years, for FBAR, Mr. FBAR and FBAR penalties. And I think it's important to note that what has started to happen is the court is imposing statutory constraints and constitutional constraints. Now, Bittner, the court imposed a statutory constraint. By that, I mean they interpreted 5314 to mean that only one 10,000, penalty can be imposed, right? Right. One penalty. That was their interpretation of what the statute actually said. That would have been a combination of 5314 and 5321. But I think that, there's all this, great victory, Bittner won. I do not agree with that. I think that was a huge loss for the American people because what the court ruled was the statutory construction of the statute did not allow for an interpretation of 10,000 an account. Point being that they're saying you could easily punt this back to Congress and they could impose, a penalty on 10,000 accounts. So I do not see Bittner, as a win for the American people. It was a win.
No, it's not at all. Yeah, no, because the problem with Bittner is the Supreme Court upheld the FBAR penalties. And it's frustrating when you're reading the oral argument, when you're reading what's happening, it's like, guys, You can't even see yourself. There's no authorization. You're right there. You're right there. And the argument just wasn't raised. And so, I think that if a SEC versus Jarkesy Seventh Amendment claim is raised, big problem. And if a Loper-Bright argument is raised for Supreme Court, big problem for the government. Those are the two ones, by the way, that aren't being brought. Everything else, like, well, that seems to be the most clear one there. And I do, when your comment before, is the tax industry part of this? And I'm like, some of it seems like they're steering these cases the wrong way. Like the winning argument is avoided, and it's kind of frustrating. To see, like, why are we going there? Why don't we go to the winning arguments? And I don't know. I'm not sure why it's what's going on there. But there's something.
That's statutory constraint, okay? But it's important that statutory meaning can be changed. In contrast to constitutional constraints, next slide. So this is interesting because what we're beginning to see are court rulings that say as a matter of constitutional law, the IRS can't do what they're doing, right? Now, one of them is the recent Sagoo case. This, jury trial is required in certain instances. I think we talked about this on a previous podcast, but the point is that this is a constitutional constraint, right? Measuring the content of the statute against the Constitution. So that's important. And of course, we have in Schwartzbaum the Eighth Amendment ruling that said, yes, FBAR penalties can be subject to the Eighth Amendment excessive penalties clause, right? So we're beginning to see the court putting constitutional constraints on the government in this area, which is a good thing. Next.
Yeah, and Sagoo, I would say, is sort of, if that one gets upheld, it's like that's the end of the FBAR. That's a fantastic case. But the DC wants to bring this no, we have a better idea than in Texas. So here we go. All right, and now I know Keith has to hop off fairly certain. Yeah. Keith, soon. So what is I'm checking your temperature here. I realize we've gone off. We've gone into our technical land a little bit here. So right. What's your impression so far of what we're talking about?
I don't know. I mean, it's just, obviously, there's extraordinary circumstances in every case. So I don't know what to say. I really don't. I mean, I deal with a lot of people who have never filed an FBAR in their lives.
Yeah.
So, and then some that stopped many years ago and some that are, it's just so many different things. Oh, and I think what's hard is just, there's no black and white. There's a lot of gray. You know what I mean? And,
and that's kind of what we, the role of a tax attorney is to try to interpret what the practice of law is and give the advice, not what the law is. And now I remember the point I was trying to make before. And when we're talking about, when John was talking about how the FBAR is supposed to be remedial, and because Keith, you just said, people just stop filing FBARs, they're just not going to do it.
Yeah, they've stopped like 10 years ago, or right. 10, 5, 6, 7, 8 years ago. Yeah.
Because that risk of filing something creates a risk of a penalty, right?
Yeah.
And this is really how depraved you know this. They're vindictive. They're operating outside the law. They're operating outside the Internal Revenue Manual, and this is how you know it. Because if an FBAR penalty is supposed to be remedial, what is the purpose of an FBAR penalty against your estate? Because you're dead.
Right. Yeah.
Like what's that about? Like
it's really to punish and to raise money. I mean, look, the local school board needs to raise money. They have a bake sale. The IRS needs to raise money. They go out and post some FBAR penalties, right? I mean,
Right. Yeah.
Well, again, the money's a drop in the bucket. It's not the money; it's the terrorism that's the value.
Yeah,
that's
exactly.
the value. The actual money, they don't care about that.
Well, I mean, the money can be significant. It could ruin you.
Well, no, it's big money to you. A drop in the bucket. They don't care about the money for them. But yeah, sure, it's big enough for you to terrorize you. That's why they're doing it, right? Because it's pure terrorism. Yeah.
Well, gentlemen, I'm going to have to scoot because I actually have a consult call at 8:30 with someone who needs some guidance. So,
all right, great. Well, all right.
And that's what I do. You can let people know toward the end.
Yeah, I will let. We'll hop off. Yeah, Keith is. As Keith's going, if you are an expat and you're wondering, because it is so frightening what to do, talk to Keith. He also runs the American Expatriates group. I know we have a lot of people from that group on here now, but you might want to join that. And also you can email him directly at US_overseas_advocate@outlook.com. What should people know about contacting you, Keith?
Well, just contact me, and and we talk about, based on your profile and situation, we just go through different real options and formulate a short-term and long-term strategy. And again, there's no cookie cutter answer. It's based on your particular profile and circumstances.
And I just want to mention this because this is something you and I have noticed. I think over the last 2 years, it's really been picking up. A lot of the questions involve inheritances. So that's a lot of
very
issues.
Much so. Very much, and that's why I tell people they need to be proactive.
Yes. So that these could, and I think what I'm seeing is like 10 years ago we did a lot of a lot of streamlined disclosures. Now those clients are moving into like, okay, we have some stuff we got to figure out here.
Yeah.
So all right, very good. Well, thanks so much, Keith. Thanks for joining us today.
All right. Talk to you later, gentlemen. Take care. Bye-bye.
All right.
We've talked about OVDP, next.
Yeah, and by the way, that over 50%, if that's what it ended up being. So it's like, well, the OVDP is like, hey, commit suicide, because otherwise we may assess you a 50% penalty. So why don't you come and pay us a 50% penalty?
Look, the reality is that the penalty regime was so extreme for this that I honestly, if anybody understood this, they wouldn't do it, right?
Yeah.
So the question is, I mean, the penalties are so extreme. Like, what are the Barrireau supposed to do? I mean, if they gave them $100,000 penalty, maybe they'd pay it, but I don't think they're going to be responding. What's the point? I don't think they can pay that. I doubt they have the money. I mean, and this is part of the problem, right? Where you have a tax administration that's based on, numbers and theory and not reality. And also it's so incredibly punitive. I'll tell you where the 50% comes from. In one of the later renditions of the OVDP, the standard offshore penalty was 27.5% unless you had an account at at a bank that was on a list of bad banks, in which case right. So if you had your accounts were at one of the bad banks and it was a 50% penalty, then it would have cost your full net worth. Okay. I mean, like it's so crazy, okay, that only advisors who didn't understand this program, which is probably most of them, and and therefore clients who didn't would have participated in this. It's so crazy. And also, I mean, put this in context, right? What were the Barrireaus trying to do? Come into compliance. I mean, is this now the lesson? Come into compliance, you'll be ruined.
Right, right. And the government, they don't even get it. They don't even get it. Like, okay, you're kind of creating, because it's just uncertainty, confusion, and the ability to at any point to ruin whoever you want. And that arbitrariness is really, what the government likes to terror. That's what terror is: arbitrary violence. And that's what the government does. And they're just, hey, look, we had to go after somebody because we need to terrorize everyone at large. Hey, man, the bomb just happened to hit you. That's all. Hey, man, it's nothing personal. We just had to attack you to get everyone else. Sorry. That's
got truth to that. But on Keith's thing about talking about people who filed FBARs in the past stuff, one of the things, I think this was in the statement from the government, was that at least for something that was in there, from that I inferred that the fact that they'd filed an FBAR many years earlier was evidence of willfulness, and that's what they're tagging the willfulness on. So, I think that an important lesson here is if you're filing FBARs, you better continue. Anyway, next.
Well, there's actually, I think if we look at the statute, there's no requirement that it's a yearly, just as a report. So why do you need to file another one if you look at the statute? And does the IRS consider that a factor? No, not at all. Because again, this has nothing to do with compliance. This only has to do with financial terrorism. That's the thing. One thing I would add too is that I did talk to the developer of the 2009 OVDI. Can't remember his name. He's an attorney. When I talked to him, it was 2016. He was an attorney in private practice in Miami. He said, it is utterly ridiculous that the IRS is taking this program that I designed specifically for people who were engaged in criminal conduct of of moving money around, of tax evasion, and now they're applying it globally to anyone potentially who actually has, in order to have criminal liability, there needs to be some sort of criminal intent. And the IRS just made a blanket intent, basically foreign account ownership. We can infer you are a criminal, and that is exactly what happened. We can do it because you know what? We hate you. And so that's where these things have gone off the rail. I mean, there's so much wrong to this, every which way. I really, it's just, it's getting a little bit. Oh yeah, here's the. So you wanted. This is the opt out that we did.
This is the exact quotation off the FAQs for the 2012 OBDP. God, this is exactly what it is. I want to read this in, okay? Because this is what they say about if you think that the standard 7.5% is unfair. Now, in the Barrireau case, they owe no tax. They just haven't, filed some forms. So an opt-out is an election made by a taxpayer to have his or her case handled under the standard audit process. It should be recognized in a given case the opt-out option may reflect a preferred approach. That is, there may be instances in which the results under the applicable voluntary disclosure program appear too severe given the facts of the case. There will be other instances where this is less clear. In the latter case, the service will look to ensure that the best interests of the service and the integrity of the voluntary disclosure program remain intact. In these cases, expected the full scope examination will occur if opt-out is initiated. It is expected that opt-out will be appropriate for a discrete minority of cases. Now, first of all, what they're really saying is that if you opt out, we're going to punish you anyway. That's obviously what they're saying.
Yep.
The other thing that's interesting about this, right, is they're saying, if you opt out, we're just going to apply the law to you. And the point that I want to make is that applying the law of FBAR means that there's no penalty required. Okay, and I think this is extremely important. This is not mandatory penalty assessment at all. But anyway, next.
Right. It's like, it's like the IRS believes it has a property interest in assessing the highest FBAR penalties available. That's what their assumption is. And again, when we read this, it is expected that opt-out will be appropriate for a discrete minority of cases, whatever discrete means. I don't know what that modifier is. First thing is that, what the hell is this FAQ? Who wrote it? We don't know. When we look at regulations, you'll see someone's name. Who wrote this? And this is, by the way, this FAQ is simply HTML code on a website. And this is what became the law.
Right.
This is the law on OBDP. What the hell is it? It's not a regulation. It's a nothing. It's just like, this is what we'll do if we feel like it. And this is the government saying, when it says we expect that opt-out will be appropriate for a discrete minority of cases, because you're saying that mostly everybody who hasn't refiled an FBAR is willful. Therefore, you've made it, you are making a claim that the ownership of a bank account overseas is a default criminal act. And these are all determinations made by government employees. All the government employees, those like, hey, look, we got together, we had a lunch break, we went out for lunch, we talked about how much FBAR penalties we should assess. We said, hey, this person was willful because we thought so, and we should be, this is how much, and we put a judgment, and we want to ruin them. Hey, after lunch, we agreed. This person was guilty, and we should go after him. What's the problem? What's the problem with IRS employees just getting together and ruining people's lives for whatever? That's what we have.
What Americans expect of their government. That's the whole point, right? Next.
Yeah.
So, we take the thing apart. We looked at the thing from Tax Notes. I mean, this is really, really extraordinary stuff, and it's not the only one. There have been plenty of instances of this, not as a percentage by any means, not as a percentage, but there's been a lot of FBAR and penalty abuse. And the way this works is that, it's very hard to, defend against this type of stuff. It's hard to know, where to look and stuff like that. But I think that, this is a very serious problem. And I heard a suggestion a while ago that there ought to be sort of an FBAR help center set up on the retail level worldwide to, provide pushback against this type of stuff. Because, look, by any standard, by any moral standard, on the planet, okay, what's going on here is completely arbitrary, capricious, unjustifiable. And, the behavior of a government that is completely out of control and that is no longer worthy of being called a democracy in the sense that individuals
It's a
have any
mafia. It's a
control.
mafia. That's what it's a mafia. It's a mafia that doesn't offer the protection. So there we go. That's what it is. And we did discuss the complaint there. That I did put the links in the super chat to
Yeah.
to the complaint.
Let's see.
Yeah, and that's what you get for.
Is there anything else? What's the next slide? Oh, yeah. Again, just to recap, I think this is so important, okay? And I'm really convinced that, the tax profession is complicit in misrepresenting a lot about FBAR.
Yes, yes.
Why would the IRS impose $3.5 million on the Barrireau? Answer: because they want to. They could have issued a warning letter, but they didn't.
Yeah.
Again, this is critical, okay? These penalty assessments are not based on a requirement of law.
Yeah.
The law does not require that they assess FBAR penalties. So why do they do it? Because they want to. Okay?
Right, and even on other penalties, like a civil fraud penalty, the IRS doesn't have to assess that. Many times, the client had it, like, okay, you kind of get them. Nah, and there's a lot of penalties, like, yeah, we could, but you know what, you guys were pretty cooperative during the audit. And usually, and that's the thing, when you're cooperative during an audit and you're nice to the examiner, you just send a little letter at the end. Thank you so much for helping my client understand his roles. We understand, we agree with everything, da-da-da. They'll probably not assess any penalties. That's normally how it is, but FBAR penalties are special. They are special, and they just have to be assessed at the maximum at every possible time, any case, because, there is some sort of, and again, this is what I would say. I do need, I do think I need to, I did try to get a FOIA, because the National FBAR Penalty Coordinator is someone who coordinates all the FBAR penalties. And the IRS FBAR Penalty Coordinators tells the IRS Independent Office of Appeals how to assess FBAR penalties. And so that is the IRS Independent Office of Appeals isn't independent at all, because they have to take marching orders from the FBAR National Coordinator. That person right there, they might have a little bad mojo, a little bad energy to them. I really do wonder. That's a sort of satanic sort of lifestyle. I got to stay, just going around and ruining people, and it's really bizarre. So that the reason why they wanted to, and I think that's the best way to put it, is they opposed that because they had someone they could, and they wanted to, because now, hey, expats. Hey, Americans, look, if you don't do what you say you do, we're going to ruin you. And you know what? If you don't understand the law, that's your problem, because we can ruin you. We're on top. This is just a humiliation ritual. That's what it is. It's a humiliation ritual, so people make sure they fear, loathe, don't trust their government. And again, that government is all powerful, and that to create an image that government's all powerful. But hey, look, I don't know how long that's going to last. I think that people are waking up here. I mean, it's everywhere. People are waking up to sort of the divorce of the law from this government. And I don't think people can blame Republicans or Democrats anymore, because it's a little different than that, I think.
They blame themselves. They blame themselves. They've created this government over the years. It's
I don't believe in any of that. I don't believe in any of this. No, I don't believe that people created this. We didn't vote for this. We don't have a government that represents us in any sort of way. The people who we're given to vote for are entirely contrived. And by the way, when the government assassinates leaders, that actually means the government's no longer legitimate. So it's over. It's over. There's no legitimate government. No. I don't care. Whatever you're doing, whatever voting we're doing after JFK was assassinated by the CIA. I don't care. It doesn't cure that. It doesn't cure when after RFK was assassinated by the same government. It doesn't cure that. Future elections can't cure all these political assassinations that have occurred over the years. That is the problem. So let's not. I can't pretend this is not a democracy. It hasn't been. Not that it ever was, but nor is it a republic. Because we just are. We have a government telling us we have a government who tells us who to vote for, and then let's be honest, these elections aren't exactly on the up and up. And let's also look at the primary elections. I can't believe Lindsey Graham wins primaries after primary. Give me a break. This is not any sort of we're a hostage people. We're a held hostage, and the FBAR penalties are proof of it.
Anthony, for years I've been saying that you and Keith ought to run for president and vice president.
I want to run. I want to be judge
to the next level.
I don't need politics. I don't need it. We don't need it because we are sovereign. If I think I need to run for president to have rights, then I already lost. I don't need to be any. Yeah.
The people of America need you.
The people. Well, I am the people. That's right. The people do need it, and they do need a little push. I do think people need a little push, waking up to the law, and that's number one. And this is where I say it's like, I don't think we need any violent revolution whatsoever. We already have the law on our side, folks. The law is 100% on our side. The person who's got the problem is the federal government. What they need to do is make sure they continue to lie to us, and we need to make sure we continue to believe their lies. But once we understand the people are sovereign and that the public officials are our servants who have no authority to interfere with our fundamental rights through their statutory interference or their executive interference. Either way, they have none. As soon as people, and it doesn't even need to be that much, I would say less than 10% of the people. That's all it needs, because most people don't even care about it. 90% of the people care. I don't know how many people can even name the 3 branches of government are supposed to exist. It's very few people. So we don't even need that many people. We just need the right people. We need the right people to wake up to say, yeah, this is nonsense. This government is totally a criminal structure that is divorced from the will of the people, and that there needs to be an accounting for what's going on. That's where we need to go. And it's not, again, we have the law on our sides. And our ancestors fought for that law. And they were smart. And they knew what they were doing. We just got to pick it up and run with the ball. That's really all we need to do.
Well,
Anthony, or we better.
Now, if you want, I've written a ton about Mr. FBAR over the years. I mean, his whole life, I've been writing about Mr. FBAR, giving accounts of his growing up and maturity. So there's more there for anybody who's interested, which I know you're not. But next.
This is all right. And there we go. Okay.
Oh, yeah. And also, look, if you really think about this, the weaponization of Mr. FBAR is definitely a sufficient reason to renounce U.S. citizenship. I mean,
yes.
It really saw what was going on here.
Yes, and you know what? And that brings me up because I think the video that we did, the family that renounces together, that was a beautiful one because that is a common thing, right? And it is so intertwined because you have to do it. And I did talk to one of the luckiest human beings on earth yesterday, the highest level of life form possible, dual citizen by birth. Yesterday, so we just we did have a great discussion about how these things get so intertwined. So it might not just be your decision. It's got to be something that can group together. And I would just say, John is fantastic. If it's something you want to get to, you can reach out to John. There is his email at citizenshipsolutions@protonmail.com. It is these covered expat rules, these covered gift rules. That's the thing. It's those covered gifts. That's the thing that say, we really do maybe need to renounce together. And I mean, this is what I would say if you live overseas. If you're an American, if you live in America, I don't know if renouncing is the right thing. Let's stand and fight. But if you're overseas, you're not connected to this. Like, you're not here. You're not here. Why? Why have this? You have enough battles where you are. You don't need this as well. And this is not, it's going to take some time, I think, for this to straighten out. I think in 10 years, things will look different. I don't know, maybe 20 years, but it might take a little bit of time for some of these things to improve. So, getting out now, yes, and I would say America needs an enema. There we go. Yeah. What was that? I think that was the first Batman one, or the 1989 one. I think that's what they're. I can't remember, dating myself a little bit. Just getting some comments. We got to hop off real soon here. Andrew, thank you for, and this is, there is, the agencies, this is just, it really does work for profit. And I mean, I think that's a good point, that these people have a profit motive. their own careers. And, this is what, I guess this is part I don't understand. People think that compensation can only happen in the form of a salary. No, job security is also a form of compensation. And a promotion is also a form of compensation. So when they litigate and they do all this bureaucratic thing, they're increasing the chances that there will be a new bureaucratic department that they will be the chief of. That's the thing. So it is Andrew, you're absolutely right. It is a for-profit enterprise. Yeah. You want job security and more power and more promotion, and you will do anything. Now, it's not the most efficient way. I understand that. That no one's, that they're going to assess these $3.6 million, whatever it is. Yeah, the percentage isn't really going to them, but rather the whole structure supports more bureaucracy, which is a profit for them. 100%. That's absolutely true on that, Andrew. Great point. Software's got a question here. Is the FBAR for individuals only? How does it work for married couples as far as the threshold that has? Yeah, that would right there, 5,000, 5,000. Then no, right? That's not a joint filing. You would not have an FBAR obligation, right? According to their own bizarre rules. Of course, we all say you have none. According to the rule of law, you have no FBAR obligation. According to their bizarre unconstitutional rules, that would be a case in which you don't have to file it, which is always sort of the problem that you have when you're trying to advise people on FBAR rules. Like, well, we'll have a law that says this, but this is kind of what they do. What do you want to do? And that's sort of how you know. And then I would say this. Renunciation. Thank you, Andrew. Renunciation is evidence that the government is engaged in an abrogation of rights by legislation. Boom, right there. The fact that you're renouncing is proof positive that the government has done, destroyed us. All right. Well, I want to appreciate everyone who's. We do have to hop off. I want to appreciate everyone who showed up today. Thank you so much for the great comments, great discussion. This is absolutely amazing. Be sure to subscribe here to this because we'll be covering more of this. And also, I'm going to try to. I will be. If you look in the description, folks, and the URL is a little too long. And let me try to get this up here. What I've done, and we've been doing this because some of the things I discuss, I get a little bit more common law and a little bit more interesting. I have a private group I created. Finally did it. Let me get it up here. And if you look in the description, if you want to join this, you can, in the description, I have a link to join this. I'll shorten the URL. I just got this up. But every Friday at 9 o'clock, I'm doing a call. A lot of these are clients, but a lot of it's just sort of strategy and thinking. And a lot of it could be therapy in a way. It might be a little therapeutic to do this. Not that many technical tax things I discuss, but really the overall, like, how do we live lifestyle with this thing, right? So the link in the description, you'll see that clumsy link in the description. It's kind of awkward. Hopefully I can find a shortener for it. But that's going to take you, invite you to this right here. And this is where I was just I'm going to be posting John's slides and things that I'm, post discussions here. And I'll put a link into this video. Hopefully I can go through all my past videos and then get that. If anyone wants to volunteer for that, by the way, I could definitely use a volunteer to get all our content so that people can find stuff and really start the discussion. So that's something there. So look in that link below. You can join that. And also, if you do, and also just send me, you can just email me. If you want to join it, I'll just email. And if that's too hard to find that, you can just email me directly, and I'll send you a link to the weekly group. Where is my email? Right up here. There's my email, aparent@irsmedic.com. So if you want to join this, that might be the easiest way. Just send me an email. I'll send you the link. You can join and get into the conversation. We had some great people. We had a few people from here on there. It was wonderful. The great conversation. It was really something different, a little more private than YouTube. And it's nice. And I was able to get into things I don't discuss that much here. So with that, and now I just want to thank John. And now we did give everyone a call to action on John. If you are thinking about renouncing, there's a man, John. Again, and by the way, thank you again, John, for these slides. Utterly fantastic job. You make it so easy for me. You make it so easy for me to be awesome. Thank you. Thank you. Also, be sure to follow John at Expatriation Law on Twitter, and along with Keith, he's on there. It's Keith Redmond. He's on Twitter, and along with me. All right, guys. Thanks so much for today. See you next time.